Thank you. All right, you're Derica Johnson. And Ms. Johnson was previously in court, entered pleas of true in a motion to revoke probation to counts 1 through 4. On probation for aggravated assault causing serious bodily injury, and that was a 6-year deferred probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
And there was no agreement, correct? I'd agree. Also, just for everyone.
This is one of those hearings where you can feel the patience is already gone. When a judge starts by listing how many chances someone's had, that's not small talk. That's a warning. Miss Johnson isn't here for a first mistake. She's here because the court already bent over backwards, and she still didn't meet the bare minimum.
Book probation, send her to prison, or to try one more time and get her some help through either ISF or SafeP. In discussions with Miss Johnson this morning, she, I think the option that she would rather do is to ask the court for some mercy and give her the lowest amount of time in prison possible. We would request something in the neighborhood of 2 to 4 years.
Listen closely to what the defense is actually asking for here. They're not arguing innocence. They're not asking for treatment. They're asking for less prison. That alone tells you everything. When even your own lawyer is negotiating how long you'll be locked up, the fight is already over.
Ms. Malfino?
Judge, I concur with Ms. Lopez's updated PSI. It's very thorough and goes through every opportunity this individual has been given by the court. It's a shame she doesn't want the help. Really could help her. I mean, if she was using last time while she was pregnant, she's obviously somebody who has an issue that needs to be addressed. But she doesn't want the help, and she shouldn't take up someone else who wants the help spot. And so I think revocation is appropriate with something in at least in the mid-range.
This is where the tone shifts. Drug use while pregnant. Multiple chances at programs. Turning down help. Courts don't just offer treatment endlessly out of kindness. They do it because prison is the last resort. When someone refuses every off-ramp, the road only goes one way.
Like she had one prior MTRP and was given 120 days sanction at that time in 2023.
I mean,
the facts of the underlying case, I think she threw a bottle at a girl and waved a knife at another. We pled on dismissed from originally. I think nobody was injured, judges, just threats basically.
well, she threw the bottle attempting to hit someone else, but it hit someone, but it hit someone else in the head. Well, there's no accidentally. You meant to hit somebody with it. You just hit the wrong person.
And notice how the judge shuts down the nobody was really hurt argument. Throwing a bottle at someone and waving a knife isn't accidental chaos. It's violent intent. Hitting the wrong person doesn't make it better. It makes it worse.
No, because Ms. Johnson, you have been coming here now way too long and been given every single opportunity to stop talking over me. Because right now, what you're looking at that I can do is give you between 2 and 20 years in prison. And the more you talk over me and are disrespectful, the higher number that's going to get. Do you understand? You have been, I'm not even sure how many times now that you've been in here pregnant, using drugs while you're pregnant, while we're trying to get you help. You have 5 kids that you have no custody of. It's the jail incident reports are ridiculous. And then you want to come in and say, I just want to get this over with. Give me a couple years in prison, which you probably have credit for, which is absolutely not what I'm going to do.
This moment is raw. The judge isn't yelling to be dramatic. She's spelling out consequences. 5 kids, no custody, jail incident reports piling up. This isn't just about punishment anymore. It's about public safety and responsibility. And the disrespect, that seals it.
All right, Ms. Johnson, this time I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit for any time that you've been in custody that the law gives you the right to receive. Am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Rojas about that. I'm also handing you the trial court certification, the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Good luck to you.
12 years. That number didn't come out of nowhere. It came from years of ignored warnings, broken trust, and burned chances. This is the system saying we tried mercy. Now we're done. And that deadly weapon finding, that follows her long after the sentence.
So in 2015, you were not a juvenile.
2015, that when that conviction was like, I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time, and I did parole. I did good behavior.
Right. So you should have learned. Not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you understand and that you can't possess a firearm, but you've already gone to prison for that. So
I was at the wrong place, wrong time. Now, I mean, it wasn't my position due to the fact that I am a felon. I'm not denying it, but I'm saying I would deserve I feel like a second chance or something.
Well,
I always keep like I don't want to get thrown in prison, come out when I'm 38, something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. One was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. I'm going to sentence you to a term of 6 years.
Then we see the second case, and it drives the point home. Prior convictions. Same mistake. Same excuse. Same outcome. Judges don't sentence based on speeches. They sentence based on patterns. And both of these defendants showed the same one, knowing better, and doing it anyway.